Welcome to Goodman Law Group. Today's Webi-law-r is going to be covering transfer fees and disclosure statement fees and the difference between both. Before we get started, I wanted to make sure you're aware. Everything I'm going to say today is for educational purposes only. It's not attorney-client privilege. There's no attorney-client relationship by virtue of what I'm going to say. This is basically a Webi-law-r, or a webinar, I guess. I'm Clint Goodman, and I've been practicing HOA law now for 14 years or so, and I'm the founding attorney of Goodman Law Group. You know, the last couple of weeks we've been getting a lot of questions from board members and from managers. Interestingly enough, it was just, they all came in at once and said, all these questions were, hey, listen, we've got problems with disclosure fees, or can we charge this at closing? Can we charge that? And the answer basically is statutorily driven, and if you don't have some things in your CC&Rs, not articles, not bylaws, I'm talking about CC&Rs. If you don't have them in the CC&Rs, you may not be able to charge it at closing. So we're going to talk about that today. But what I found interesting is we've been having several of our clients concerned or confused about what a disclosure fee is and what a transfer fee is. Transfer fees in Arizona are a little different than disclosure fees. But the problem is the confusion comes from the statute itself. The statute itself defines disclosure fees as transfer fees too, whereas other states don't have that. So let's just dive right into it. So let's start with disclosure fees. The statute for disclosure fees, we sometimes call them resale disclosure statement fees or disclosure statement fees, and the statute says they're transfer fees, but it's ARS 33-1260 is where you'd look if you're in a condominium. If you're in a planned community, it'd be ARS 33-1806. So what the statute says is it says that if you are a condominium or a planned community with less than 50 doors, then the members have to provide, the seller has to provide all these statements. But if you're a condominium or planned community, the statute obligates the association to give to the escrow or closing or whoever within 10 days of the request a statement of a bunch of things. The statement includes the CC&Rs, the rules, the policies. It includes the financial summaries. It includes a statement of if there's any pending litigation other than collection lawsuits, that kind of thing. And you should take a look at the statute or talk to me later one-on-one if you have additional questions about what that disclosure statement fee is. Now, we know a lot of communities actually get requests from escrow, even when it is less than 50 units or 50 doors. And that's fine. You can still provide it, that information, the disclosure statement, to the person that's requesting it. And what the statute says, it says if you are disclosing this information, you can charge a fee for it. And it puts a cap at $400. And it says that that is a transfer fee and it can only be $400. So that's where the confusion comes in. Is it really a transfer fee? No. We're going to talk about what a transfer fee is in a minute, but the cap is $400. And if you're not charging the $400 cap at that time, you can't just bring it up to $400 immediately, but you can charge 20% each year and increase it by 20% each year until you have the $400 cap. And there are a few other rules with that. One is that $400 isn't what goes to the association. That's important to remember too. It's the money that goes to the management company that's preparing the statement. If you're self-managed, obviously then you can charge the $400. But that statement, that $400 is what you charge to provide all of the disclosure information you're required by the statute to disclose. Let's say they ask for a rush fee. Well, you can charge a rush fee of, and I'm looking at the statute, so I hope you forgive me, but a rush fee of no more than $100. Another thing is, and the rush fee would be if it's required within 72 hours. Finally, the association can charge up an update fee, a document update fee of no more than $50 if it's been at least 30 days. Now, it's also important to note that there are times when you cannot charge that disclosure fee. You cannot charge it if it is a transfer because somebody died and they're sending it over to their children. So if it's basically an inheritance, you don't charge it then. Or if I have an LLC that owns it and I decide to create a new LLC and I'm transferring it among my own entities, you can't charge it then. And there are a couple of other exemptions of when you cannot charge it, which are few and far between, and I won't get into it now. If you have questions, you can call me later. In fact, take a look at my contact information below, and you can just get a hold of me later. Now, the whole purpose of today was to get into what transfer fees are, because the transfer fees that are confusing a lot of folks. I've had, in the last 3 weeks alone, 3 clients come to me and say, hey, can we charge a transfer fee in addition to the $400 cap? Because they were given, frankly, bad advice from another attorney. One of the other attorneys, not in the HOA world, but another attorney outside of the HOA world who was playing HOA attorney, said that you cannot charge any fee above the $400, period. And what happened was the manager called me and said, look, Clint, the board's attorney said we cannot charge this fee, but the CC&Rs say that when there's a closing, we can charge a capital contribution fee, a reserve contribution fee, and a transfer fee. And they got the advice from the other attorney that they couldn't charge anything above the $400. But the CC&R said that the working capital fee would be worth 2 assessment amounts, and that would go to a working capital fund. The reserve contribution would be X amount. I can't remember if it was 2 or 3 months, but whatever it was, and that would go straight into the reserves. And then the transfer fee said that the board could establish an amount at closing that would go straight to the association's operating account. As you can see, that would be different than the management company for the disclosure statement. So the statute that controls transfer fees is ARS 33-422. And this applies to both condos and planned communities. And what it says is that if you have a transfer fee in your CC&Rs, you can charge it. If you have a provision in your CC&Rs, not articles, not bylaws, but in your CC&Rs that says that you can charge a reserve contribution fee or a working capital fee at closing, you can charge it. So if I were to look at the statement, closing statement, of all the different charges that go here or there, we'd start with what we talked about at the very beginning of today's class, and that was the disclosure statement fee of $400. That goes to the management company. So you'd see that line item there. The next one, if the CC&R say transfer fee, let's say it's $500, $250, it's worth 2 assessments. So, and your monthly assessment's $250, so $500. And I'm making these numbers up for illustration purposes, but so that $500 then goes straight to the association's operating account because the CC&R say there's a transfer fee. Go one step further, the CC&R say there's a reserve contribution fee, another $500. Let's say that's what it is. That goes straight to the reserve contribution fee, not to the management company, not to the association's operating account, but to the reserve account. Now let's say there's a working capital contribution fee or whatever it might be. There's many different names for this, but let's say it's a working capital or capital contribution fee. That goes to the operating account or to a capital account, whatever the association's board is set up for that. So those don't go to the management company. And if you add up all of those things, let's say it was 400, then 500, 500, 500, you know you're now at what? $1,900. So clearly you're above the $400 cap already, but you can charge those other amounts as transfer fees. So you can see, as long as your CC&Rs authorize the association to charge more than the $500, and as long as those transfer fees are going straight to the association, not the management company, but the association, you can charge it. So your next question is, well, I don't know if my CC&Rs give me that authority. Or we as a board adopted a resolution years ago and have been charging it based off of a resolution or a policy. Well, the statutes, both the Condo Act and the Planned Community Act, say that resolutions, policies adopted by the board are considered rules and regulations. The problem you have then, though, is, or could have, is this statute 33-442. That statute, the default is, look, transfer fees are prohibited unless otherwise provided by contract and deed restrictions. And that's why it's important that it has to be in the CC&Rs, because a rule is a adopted policy by the board. It's not a deed restriction. CC&Rs are considered restrictions or servitudes. We've had a few folks come to me and say, well, we've been charging these fees for a very long time, 10 plus years. Can we continue to do so even though it's not in the CC&Rs? Well, the answer to that is maybe, but you need to get advice of counsel. So again, email me, call me, and we can chat, or anyone at my office. If you've got another friend here at the firm, another attorney you'd like to talk to, please get a hold of us. We're happy to help. Any call that you make to us that takes less than 10 minutes, we don't charge for. So you don't have to worry about being nickeled and dimed. But the bottom line here is that if you do not have the transfer fee, reserve contribution fee, or working capital authorization in the CC&Rs, you're operating in the gray area and you need to get legal advice. You don't have to have the disclosure statement fee, the $400 fee that we're talking about. You don't have to have that in the CC&Rs. That is a function purely of statute. It's created by statute. But because 33-442 does place a limitation on when you can and cannot charge for transfer fees, and because those other categories all fall under transfer fees, you have to have it in the CC&Rs. Now the next question is, probably you're asking, how much is it going to cost for us to review the CC&Rs, let you know, one, if you can charge it, because boards want their safe harbor. And number two, if you don't have it, what's it going to cost for you to get it done? Well, we're doing a fixed fee, and the promo rate right now is we're willing to review your CC&Rs and give you an opinion for $175. And then if you do need to amend your CC&Rs, we're willing to give you all the paperwork you need to amend your CC&Rs for $500 fixed fee. So you know there's a total investment there of $175 for the initial review and then $500 for the actual paperwork if it is something you need to do. That basically wraps up our Webi-law-r for today on transfer fees and disclosure fees. I see that several of you have questions. A lot of those questions are specific to your specific documents, so I'm not going to get into that now. But afterwards, I'll give you a call. So please reach out to us if you need more information from us, and we'll go from there. Thank you for joining us, and we'll see you next time. Bye-bye.